Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, as we know, we have been going through rather tumultuous times as it relates to guns, gun safety, gun violence, and of course, gun control. And last week we learned that an agreement in principle had been reached in the United States Senate, which would allow for the passage of some significant gun control legislation. Part of that was a national push for universal red flag laws around the country. Well, you've probably heard a lot of horror stories about them, and as someone who practices in a state that's had red flag laws for several years, let me tell you that most of those stories are in fact true. So today we're going to spend a few minutes talking about the many constitutional deficiencies of red flag laws. Okay, so the topic we're talking about again today is red flag laws, trying to get many of you around the country up to speed on how do red flag laws work, and more importantly, how do they not work. Why is this? Well, we know that the United States Senate has apparently agreed in principle on some gun control legislation, which would include federal funding for red flag laws throughout the nation. Now, currently, there are 19 states in the United States that do have red flag laws. Washington is being one of them. We've come up with a much more euphemistic term for them. We call them extreme risk protection orders, or ERPOs. But that means that there are 31 states currently in the United States that do not have red flag laws. Now, many of you around the country may not be familiar with what these laws are all about. What do they do? How do they work? And how bad are they? I know you're hearing a lot of horror stories. So what we're going to do today is we're going to kind of go through some of the constitutional arguments that are made about red flag laws. And as a person who's practiced in a jurisdiction for a while, I'm going to tell you what my impression of those are. Okay, so the minute any state legislature starts kicking around the idea of implementing red flag laws, those that are opposed to it are going to immediately scream that they are unconstitutional. Now, red flag laws have been challenged on a statewide level in several states. However, is there any significant opinion challenging the constitutionality of red flag laws in the federal courts, Court of Appeals, the United States Supreme Court? No, but we know that day is coming. But I think that the arguments of the unconstitutionality of red flag laws are actually well-founded. And in fact, I think many people are missing a potential third constitutional argument. Let's start with the most obvious. Do red flag laws violate the Second Amendment? Okay, well, just so we're clear, the Second Amendment reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." And of course, to many, anytime you strip someone of their Second Amendment rights, they're going to say that that on its face is a violation of their Second Amendment rights. Now, I believe that there are certain offenses, and certainly the law agrees with me that there are certain offenses when you commit violent felonies, when you commit sexual offenses, when you commit other violent offenses, that you are, by operation of the law, going to lose your right to possess a firearm. And for many of those individuals, there is an opportunity at a later date to restore. However, in those instances, let us not forget that the individual was tried and found guilty under a court of law before those rights are stripped of them. And in this situation, under a red flag law, that is not the case. So, is it possible for red flag laws to encroach upon your right to keep and bear arms? It most certainly is. And why is that? Well, it's because of the violation of the other constitutional amendment that I think is even more severe, more acute, and more obvious in how red flag laws are carried out. So let's talk about the very obvious violations of one's Fifth Amendment rights through the use of red flag laws. So now we have to talk about the violation of your Fifth Amendment right of due process and how this occurs, not so much in the manner in which red flag laws are passed or the language contained in the laws, but in the procedural mechanisms used to effectuate them. This is where the greatest constitutional deficiency, in my opinion, occurs. Now, just so we're clear, the Fifth Amendment reads, "No person shall be held to answer for capital or otherwise infamous crime unless a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. And then this is the part that we focus on here. Nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Now, when we talk about due process of law, we actually break it down into two components. There is substantive due process. These are basic, fundamental rights that we as Americans are all entitled to. Life, liberty, the ability to get married, the ability to work, the ability to travel freely around the country. These are fundamental due process substantive rights. We also have, and this is very important, and this is the rub here when it comes to the implementation of these red flag laws, is procedural due process rights, which means that in all instances, if we are going to be deprived of our life, our liberty, or our property, we are entitled to a notice and then a meaningful opportunity to be heard. And it is that last component, the meaningful opportunity to be heard, where I think some of the most grotesque violations of due process rights occur. You see, first of all, by claiming that these are civil hearings, not criminal in nature, it removes many of the constitutional protections afforded criminal defendants that are not afforded civil litigants. For example, the right to counsel. For example, the right to remain silent. Now, one could choose to remain silent at their extreme risk protection order or red flag hearing. However, once the petitioner, that is the person asking for the order, has made a prima facie showing, the burden then shifts to the respondent, the person who the order would be issued against, in order to disprove some of those allegations. So if the burden has initially been met to move forward and the respondent chooses to remain silent, well, they will lose that hearing. So how does it work in Washington, and how is it likely to work in your states? Well, the petitioner will either be a family or household member or a law enforcement agency. Let me repeat that. The petitioner, the person asking for the order, will either be a family member, household member, or law enforcement agency, because in Washington state, that's the limitation by statute. Obviously, your states can get far more creative than that. Once they do that, they will file a petition for what's called a temporary order. Now, this is where the first procedural due process deficiency occurs, because that order, once the petitioner fills out and makes all the salacious allegations against the respondent, he did this and he did that, and he said he was going to do this, and he's got these guns here and these guns there, and all the allegations that they make, they then go before the court, and the court hears only from the petitioner. As a matter of fact, when this is occurring, most respondents, in fact, every respondent I've ever represented, did not even know that the ex parte hearing was occurring. Why? Because it was happening almost instantaneously, and the petitioner in the court is under no duty to notify the respondent. If the court believes, by preponderance of evidence, that there is a reason to issue an order, the court will then issue a temporary red flag order, which is good in Washington state for a minimum of 14 days, but could be extended longer. How does the respondent find out about that? Well, they usually find out when law enforcement shows up at their home with a copy of the red flag order, as well as an order to surrender all of their firearms and ammunition. So here we are, having a person being deprived of property who has yet to even have their day in court, was not put on notice nor given an opportunity to respond. Now, you're entitled by statute in Washington state to have a hearing on the full order within 14 days. However, realistically, the respondent now has to scramble around, find an attorney. The attorney, of course, has to get up to speed, understand what's going on, prepare their own case. And so typically, the permanent order hearing may not occur until 30 or 45 days following the issuance of the temporary order. And during that time, the respondent, again, is stripped of their Second Amendment rights. They cannot possess any firearm, any ammunition, and they, of course, have been ordered to surrender their concealed pistol license. Once again, all of this is occurring without the respondent ever having had an opportunity to state their side of the case to a court. But then we get to the final hearing, and one would think, okay, so now the respondent finally has the opportunity to present their side of the case. Well, Sort of. Because in many jurisdictions in Washington state, they follow the same procedures as what's done in all other protection order hearings, civil anti-harassment order hearings, and other pissing contests. So what that means is rather than having live testimony, that is, rather than putting the petitioner on the witness stand and allowing respondents' counsel to cross-examine them to determine the veracity of their stories, their overall credibility, any potential bias that they may have, any way that you could effectively cross-examine them is taken from you because many courts say, no, we're going to only do this by paperwork, which means the petitioner and any other witnesses can file any salacious allegations they want in declarations, and the respondent and any of their witnesses are basically left filing declarations saying everything in the petitioner's declarations is BS. How this is a meaningful opportunity to be heard is beyond me. I've spent now almost 25 years in the courtroom, either as a King County prosecuting attorney for a few years or now as a private defense attorney for the last 22 years. It is virtually impossible to cross-examine a piece of paper. And ultimately, if we end up with a piece of paper that says he did it and another piece of paper who said he didn't, we are left with the he said, she said. And where do you think the courts will err on the side of? So yes, the greatest constitutional violation comes from one's Fifth Amendment rights to both substantive and, in particular, procedural due process. Because a respondent will never receive notice before the temporary order goes into effect, and by the time they finally get around to doing a hearing on the full order, they may literally end up with one or both hands tied behind their back from a presentation of evidence standpoint. And finally, and perhaps even more scary than all of this, is I believe that red flag laws can also be used to suppress our First Amendment rights. You see, the standard for issuance of a red flag law in Washington state is that the respondent poses a threat to themselves or others by having access to firearms. That is the statutory burden of proof. How do individuals prove that? Well, the statute lists a litany of ways in which it can be proven, but acts of violence or threatened acts of violence certainly constitute two of the most primary grounds under which a court will order a red flag order. But let us not forget that according to at least one side of the political agenda, words and words alone constitute violence. Now, do I believe that? Absolutely not. Violence constitutes violence. Words constitute communication. But there is those in this country with a very progressive liberal agenda who have consistently tried to tread upon the freedoms provided to us in our First Amendment through freedom of speech and freedom of religion, freedom of association, and have it oftentimes talked about how words and words alone constitute violence. Therefore, if these laws are enacted and if they are implemented in the wrong fashion, does merely expressing your political or religious beliefs, which then offend somebody else, constitute violence and therefore an act upon which they can issue a red flag order? That should be one of our biggest concerns, because there is a clear plan in place to attack the First Amendment rights of anybody who speaks contrary to the mainstream progressive agenda. So, the bottom line is this. As someone who's practiced in a jurisdiction in which red flag laws have been in existence now for several years, do I believe that their heart was in the right place when they implemented these laws? For many of the legislators, I do. The problem, however, is in the implementation of these laws, because the manner in which these laws are implemented, the procedural mechanisms or lack thereof in place to ensure that people are provided with notice and a meaningful opportunity to be heard, are pathetic in many instances and absolutely, without a doubt, violate a person's Fifth Amendment rights to both substantive and procedural due process. This, coupled with the fact that it's an obvious violation of a person's Second Amendment rights and the ability to use these not as a shield, but as a sword to attack one for their first exercise of their First Amendment rights, that is the reason that all of us around the country need to be very alarmed about the implementation of federal red flag laws. Listen, for more questions related to this or anything else about your Second Amendment rights, you can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.